கவனத்தில் கொள்ள வேண்டும் என்று கேட்டு முடித்துக் கொள்கிறேன்.
Sri Imtiaz, Jaleel.
Thank you, Mr. Speaker, sir. This government loves to collect citizens' data, but hates to be held accountable. It refuses to protect citizens' data. It does not believe in due process, and it definitely does not believe that the Puttaswamy judgment is to be followed. Mr. Speaker, my objection to this bill is not that we cannot collect this data. It is not that we should not use technology to prevent crime. My objection is that the government is bringing in this law without respecting constitutional right to privacy or the right against self-incrimination under Article 20. It wants to create databases of citizens but does not want to provide any safeguards. For example, Mr. Speaker, NCRB is being empowered to maintain a database of measurements collected under this bill. What is NCRB? The National Crime Records Bureau. It was created by a notification. It is not even a statutory body. How can a legislation empower a board that has no statutory existence itself? Secondly, under Section 4, no parameters have been provided on who has the power to access this data, what police officer, of what rank. Mr. Speaker, I have certain questions for which I would like the Honourable Home Minister to answer. Under what circumstances can a cop be allowed or denied access to this database? What are the permissible uses of this database? What punishment happens if a police officer uses this database in violation of extant law? Will defendants, it's very important, will defendants in criminal trials be also allowed to use the database to prove their innocence? What will be the procedure to do so? Improper recording or handling of the data in database is a serious concern. What are the safeguards against malicious misuse or distortion of this data? Mr. Speaker, sir, my question is, what safeguards exist? One cannot be forced to provide a DNA sample or other information simply because they have been arrested or detained. This is because it is violation of their right against unreasonable searches. After Puttaswamy judgment, the police have to follow this standard. In short, collection of DNA or other measurements is only permissible if it is justified, and it cannot be a general practice. Similarly, when searching a database of fingerprints, DNA or other measurements, the police officer will have to show a probable cause for this search. It cannot be based on the mood of the cop or just a gut feeling. He has to demonstrate why he specifically searched the database. Was there any evidence? Have all other leads been extinguished? What is the basis of his suspension? This bill, Mr. Speaker, fails because it does not provide any of these rules. Is NCRB prohibited from connecting these databases to other databases, such as the Aadhaar database? Linking various databases will mean that this government can sit in Delhi and practically identify any citizen anywhere. Interlinking databases is a huge violation of citizens' right to privacy, as they allow government to identify citizens even for purposes other than crime detention. And unfortunately, this is the reason why this bill is being brought. Mr. Speaker, sir, just 1 minute. Section 3 of this bill allows government to not only collect finger and footprints, but also physical biological samples, behavioral attributes, and iris and retina scans. This is unbridled power in the hands of government and police. What are the chances that these will not be misused and exploited? What is included in behavioral attributes? Does it include gait and facial recognition? These technologies are very unreliable and heavily biased. It is concerning that the government is not even clearly saying what it wants to do. Similarly, why are biological samples being collected? Is it not a way to bypass DNA bill and bring it through the back door? Preventive detention, suspects and arrestees are not criminals. Just 1 minute, sir. There is a presumption of innocence. On what grounds are you collecting their information? Under Section Clause 4, are you saying that this data will be expunged if the person is discharged, or acquitted. A person in preventive detention is neither charged nor convicted of any crime. So how will their data be removed? We need these answers. Lastly, Muslims, Adivasis and Dalits are predominantly detained and arrested and hardly convicted. This means that your database will have a significantly large number of such people. And before I quit, I would like to, मैं सत्यपाल जी जो जिस महाराष्ट्र राज्य से आते हैं और वो मुंबई शहर के पुलिस कमिश्नर थे, मैं उनसे एक सवाल करना चाहता हूं। अगर आप ये बिल लेकर आ रहे हैं तो उसी महाराष्ट्र राज्य की एक सीनियर आईपीएस ऑफिसर रश्मि शुक्ला जी, जिसका मैटर अभी कोर्ट के अंदर गया, अपने विपक्ष के नेताओं के खिलाफ वो किस तरह से गैर कानूनी तरीके से फोन टैपिंग का मामला सामने आया है। अगर आपको यही करना है तो ऐसे कानून लाने की जरूरत क्या है? आपकी सरकार तो जो चाहे जिसे चाहे अंदर करने का अगर तय कर ली है तो वो कर रही है, तो ऐसे कानून हमारे को ये यहाँ पर क्यों?
श्रीमती अपराजिता